Hey guys, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We're going to go over this ruling it's actually on the Jones versus Abel docket, but we're going to go over it. It's only like 4 pages before I have to get back to work. But the judge has ruled on that motion to compel Vanzan to produce some information, which we'll go over. It looks like it was granted in part, denied in part. As far as the parts that were denied, that those requests have become moot. So there was really, there was nothing to grant there. So Bixio Music Group, thank you again for the 20 some more Pacer bucks. I appreciate you. That's awesome. Thank you very much. Oh, and Kim. Hey, Kim. Thanks for the 5. How's it going? All right. Am I late? No, I just started. You're good. Okay. So we'll go over this and then I gotta run, but we will talk about the New York Times stuff a little bit tonight. I don't know if I'm going to have Leanne and Ashley might join me if they can, but if not, we'll still take a look at it. It's just going to be a little bit later. So all I can do is read the ruling right now. Hold on. Okay. One second here, guys. Hey, Stuart, what's going on? How are you? All right. Let's see. So he's just kind of going over what they were asking for in the beginning of here, but we'll go ahead and read that anyways. Specifically, Abel moves to compel production of the following. 1, a copy of the Vanzan subpoena served on plaintiff and counterclaim defendant Stephanie Jones. 2, the documents produced by Jones in response. 3, communications between Vanzan and Jones and or their respective counsel about the Vanzan action. 4, documents sufficient to show Vanzan's organizational structure. And 5, documents sufficient to identify Vanzan's shareholders. Vanzan has agreed to produce documents responsive to requests 1, 4, 10, and 11. The motion is denied as moot to those requests. So some people saw, partially denied, and they didn't really know what the partial was. Here it is. Okay. Request 9 calls for communications between Vanzan and or its counsel and JonesWorks and or their counsel concerning the Vanzan lawsuit. Vanzan argues that the requested documents are irrelevant, and that if they are relevant, the court should require production of them from Jones or JonesWorks before burdening Vanzan. Vanzan is a broom closet, as I've said before. I don't really think there's a whole lot of burden there, but that's just my opinion. All right. Let's see. The motion to compel documents responsive to request 9 is granted. FRCP 26 provides that parties may obtain discovery regarding any non-privileged material that is relevant to any party's claim or defense and proportional to the needs of the case, considering, among other things, the party's relative access to relevant information, the importance of the discovery in resolving the issues, and whether the burden or expense of the proposed discovery outweighs its likely benefit. Rule 26 further provides that information within this scope of discovery need not be admissible in evidence to be discoverable. The party seeking discovery bears the initial burden of proving the discovery is relevant. Once that party has shown relevance, it is up to the responding party to justify curtailing discovery. Abel argues that the documents are relevant because they go to whether Jones and Lively conspired to obtain Abel's stolen information and sued the Sham Vanzan lawsuit to provide a veneer of legitimacy for Jones' transfer of stolen information to Lively, and whether Jones provided data taken from Abel's stolen phone to Lively before service of the Vanzan subpoena. Vanzan argues that the documents are not relevant because Abel's claims arise from Jones obtaining Abel's cell phone when she was terminated, which took place weeks before the Vanzan action was initiated. Relevancy under Rule 26 is to be construed broadly to encompass any matter that bears on, or that reasonably could lead to other matters that could bear on, any issue that is or may be in the case. Under this broad standard, the documents are relevant. Abel claims that Jones disclosed at least some of Abel's private communications to the Lively parties no later than August 21st, continued to access Abel's private text messages thereafter, and at some point transmitted Abel's stolen communications to Sloan, Lively, and Reynolds in order to harm Abel. Okay. So if you guys remember, Leslie Sloan, I believe, is the one who is alleged to have called or texted, I think it was called Melissa Nathan that day, August 21st, and said, basically, I've seen what you've said and you're going to be sued, which was a big mistake, in my opinion, because why would you show your cards right then and basically tell on yourself? Like, that was just like the dumbest thing you could do, in my opinion. So, all right. The statutes under which she brings claims prohibit both obtaining and disclosing protected information. Communications between Vanzan and or its counsel and Jones Works or counsel concerning the Vanzan lawsuit are likely to bear on or lead to further information regarding whether and when Jones obtained relevant communications and disclosed them to Vanzan or Lively. Vanzan notes that Abel's claims are subject to a pending motion to dismiss. Remember, the motions to dismiss, as far as like Justin Baldoni's claims against Blake Lively and Ryan Reynolds in the New York Times, those were ruled on. But the Jones versus Abel docket, he hasn't ruled on any of the motions to dismiss or anything regarding that. So, and I think there's only one. So, all right. If granted, this would eliminate the issues in the motion to compel entirely. So basically saying if the judge were to dismiss Abel's claims against Stephanie Jones, then this would be a thing that they wouldn't even have to do. So they're saying basically they shouldn't have to produce that right now because it's pending. However, the motion to dismiss is still sub judice, and until it is granted, Abel is entitled to discovery to try to prove her case. Abel has demonstrated the relevance of the proposed discovery. The remaining objection is without merit. Although a court may consider the availability of information from other sources when assessing undue burden on a third party, there is no per se rule that party sources must be exhausted before documents are subpoenaed from third parties. And that's what Omar was talking a lot about when we first read that motion to compel and their response to it. Aside from suggesting the information could be available from Jones, Vanzan has made no showing that it would be burdensome for it to respond to request 9. Probably, in my opinion, again, because that is like the only thing their company has done in the last 10 years, except for order some furniture. So, I mean, just like reach into your broom closet and grab the one file you have. It's really not that big of a deal. All right. The motion to compel is granted as to request 9 and otherwise denied as moot. Okay. So that's that. They're going to have to give up that information. One second, guys. Relevant photons, thank you for the 5 FU Vanscam. Vanscam. I like Vanscam better. I think that's funny. Thank you, though. Thank you for the 5. All right. Why isn't Lauren happier? Lauren is exhausted. So that's why. I've been traveling left and right, and then I leave again tomorrow to go out to LA. So Lauren is just trying to stay awake right now. But I'm happy. Don't worry. I'm happy. Listen to my words. Don't look at my face. I'm so happy. Okay. Please rest. Yeah, right. Like I have time for that. I'll be fine. Don't worry about it. I'll sleep tonight, I think. All right, guys. What does this mean? It means that Vanzan has to produce the information that they did not want to produce. Basically, they suck it, basically. They have to suck it up and give them the stuff. All right. Your hair looks great. Thank you very much. I just wet my hair. So that's all I do to it. So thank you. So we're going to go over that New York Times piece tonight. And it's pretty much the same as the bullshit that came out in the Atlantic like a couple months ago. But we'll go over that. And like I said, I might have Ashley and Leanne on if they can come in. We'll see. But yeah. All right. I got to get back to work. So I will see you guys later. If anything else comes up, we'll be covering that sometime after 5 p.m. probably, most likely. Thanks, everyone.